The Freedom from Religion Foundation has been awarding a Freethinker of the Year since 1987. The award is intended to recognize and honor successful state church litigants, or sometimes just very brave people who should have succeeded. We have honored Supreme Court victors such as Ishmael Jaffrey. Our first Freethinker of the Year in 1987 was the Weissman family in 1992. And all of our Freethinkers of the Year have been brave and courageous and deeply committed. David Steketee came to the Freedom from Religion Foundation armed with research, documents, and a resounding indignation over the misappropriation of his tax money and others' tax money in his New Jersey county. With outside counsel, Paul Griswold, and co-counsel among FFRF staff attorneys, the Freedom from Religion Foundation and David Steketee went to court and won a resounding and unanimous decision this year by the New Jersey Supreme Court in our favor, and all judges agreeing that tax dollars should not go to aid religion. So thanks to David, we've won the case. The state is now asking the US Supreme Court to take the appeal, so we'll be responding to that. David grew up in St. Louis, Missouri, and studied journalism at the University of Missouri. He has been an avid student of constitutional law since his years participating in speech and debate in high school, and became engaged with separation of state and church issues when his neighboring state of Kansas voted to exclude evolution from the science curriculum. Over the last 20 years, he has advocated for student press rights, student privacy rights, and separation of church and state. In line with what David Kalianitis had mentioned, as I understand it, David Steketee may soon be a school board member in his local community. So, David, please come up. We have a plaque for you naming you Freethinker of the Year 2018.
The New Jersey Supreme Court ruled unanimously that the use of tax dollars for the repair and restoration of religious buildings throughout Morris County by the Morris County freeholders was unconstitutional, and yet they're still fighting it. But let's take a step back to where this all began. In 2011, while strolling through Morristown, New Jersey, I noticed a sign in front of the Church Redeemer's Parish House, indicating it had received funds from the Morris County Historic Preservation Trust. I later discovered it was almost by accident the Morris County program was mentioned because Morris County, unlike other grant programs used by the church, has no requirement for public posting indicating the source of funds. After doing some research, I discovered the program had already doled out over $4 million since 2003. In 2012, I filed a complaint with the FFRF, but it wasn't until 2015 that I was able to attend public meetings for our county government and argue my point of view. After grants were approved later that year, I emailed the FFRF and asked them to proceed with the lawsuit. By this point, the program had granted over $9.5 million to religious institutions. Our case was heard in late 2016, and in January 2017, the New Jersey Superior Court ruled against us. We appealed, and counsels for the county and churches requested to move the case to the New Jersey Supreme Court, bypassing the appellate court. Oral arguments were held in late 2017, and in January 2018, the New Jersey Supreme Court ruled in our favor, ending a program which has cost the taxpayers over $11 million. You would think such a resounding defeat delivered with unambiguous language from the New Jersey Supreme Court, composed of both conservative and liberal judges, would cause any government official with an eye to justice to admit defeat. But no. The Morris County freeholders, all Republican, handed their case over to the Becket Fund. You may have heard of the Becket Fund. They were behind the Hobby Lobby case. Our freeholders summarily disinterested in my pleas to adhere to the New Jersey State Constitution, which makes clear no person shall, quote, be obliged to pay tithes, taxes, or other rates for building or repairing of any church or churches, disinterested in my pleas to adhere to the multitude of prior case law restricting the use of government funds for sectarian purposes, disinterested in the pleas not just from an atheist liberal like myself, but from church-going conservatives as well, will now allow a right-wing legal group to use the case to erode the wall of separation of church and state under the guise of religious freedom. It is remarkable to think government officials, for whom there was no more basic expectation than to follow the law, would not be persuaded by rational discussion, analysis, and facts. I cite a Committee for Public Education v. Nyquist and an Office of Legal Counsel opinion from 1995, specifically on historic preservation grants. I explained the issues with the later 2003 OLC opinion upon which the Freeholders Council heavily relied in his opinion on the constitutionality of the program. I explained the distinction between Trinity's case and Morris County's activities, all to no avail. What struck me is these politicians don't care about what's right. They care about what's good. It's easy to sell something that appears good. It's easy to get votes talking about all the good they do for the community. It's easy to convince people to ignore what's right on the promise of doing something good. The challenge, of course, is what's good is more subjective than what's right, and people ascribe different value to being right or being good. In the best of times, we can be both. In the context of our case against Morris County, I suspect we were right, but not necessarily good. And that makes this case especially challenging. On a half-mile walk through Morristown, New Jersey, where our case originated, you'll pass 5 historic church buildings. St. Peter's Episcopal, whose reverend happens to be Matthew Broderick's sister, the Presbyterian Church of Morristown, which has 2 separate buildings, the Church of the Redeemer, which also runs a soup kitchen at which I volunteered, and the United Methodist Church. These churches are no doubt magnificent historic structures, representing architecture worthy of preservation. So I would argue their preservation is good for the community. And that's the simple argument our freeholders made in support of spending over $4 million on their preservation. That's the argument which reasonably appealed to the community. That's the argument which frankly makes it difficult to argue for what's right, because what's good is visible to everyone, and what's right doesn't really impact anyone. Because in this case, nobody's taxes are actually reduced as a result of doing what's right. The impact of doing what's right is often less visible than doing what's good. Don't get me wrong, I believe we're doing what's right. And when asked by church's legal counsel after the New Jersey Supreme Court hearing if I would do it all over again, with a confused look on my face, I said, of course. I lost a friend as a result of my pursuit of this case because he thought I was hurting people who were trying to do good. Though frankly, setting aside what's right for what's popular never sat well with me. In hindsight, that friendship was not such a great loss. But the point is, this is what we're up against. Those who believe that what's good should override what's right, and that's often an easier sell. Whether it's funding restorations for religious buildings, or displaying a religious banner in a school, or praying at football games, whether it's teaching creationism or reciting sectarian prayers before meetings, or putting religious mottos on police cards, it is perhaps just disingenuous to claim they are all not trying to do what's good. Religious people often act out of the best of intentions, only to have the less than righteous outcomes. It is important we put ourselves in their shoes. It is important we understand their motivations. It is important that we have empathy for those who do not respect our perception of what's right. Because through that understanding, we can better argue in ways that appeal to their sense of good, even if we disagree on what is right. When I appealed to our local Board of Education to end a drug search program which fell afoul of the Fourth Amendment, explaining from a purely legal point of view fell on deaf ears. It was only my 4th attempt when I appealed to what was good that the program was finally halted. It was only, rather than explain how the law violated the principles of TLO versus New Jersey, or how the likelihood of discovering drugs resulted in a constitutionally suspect search, or how the available data simply did not support the state attorney's general requirements for suspicionless search, I asked him to consider the impact of hauling a high school student, possibly one of our low-income students, possibly with parents who didn't speak the language or have access to legal counsel, in front of the county prosecutor and local police because his backpack might smell of marijuana because his grandmother has a medical marijuana license. It was this scenario that rang true. It wasn't the appeal to what's right, but rather an appeal to what's good. It was a deeper understanding of the motivations behind the program, a genuine desire to do what was good, that I was able to alter my approach, to expose the potential harm, and ultimately persuade them to do what is right. Whether in our case against Morris County, or drug search programs, or religious prayer in schools, I think we should not always assume that those we disagree with are acting out of malice. I suspect in most cases they genuinely believe they are doing something good, and so, to the degree we can change people's point of view based upon a sense of what's good, the easier it is to convince them to do what's right. Thank you for all of your participation, all of your hard work, all of your donations, and especially to our legal counsel at the Freedom from Religion Foundation for taking on this case. Thank you.